But let me bring Mr. Chandrashekhar into the conversation. Mr. Chandrashekhar, in addition to what we've just heard there from Gopal, Rahul and Apar, let's talk about what this in fact means for the regulator, the current regulator, that is the TRAI, and what this does for the DOT. I mean, as a former DOT secretary, when you see the bill in its current form, how do you feel?
Well, I think much has been made of the so-called whittling down of the powers of TRAI. Actually, this relates to the licensing segment, which actually comes under Section 11A of the TRAI Act, which actually falls under the recommendatory powers of TRAI. So even today, in any case, the TRAI's powers there are only of recommendation. So I don't see why there should be any hesitation or reluctance on the part of the government to obtain those recommendations. TRAI's recommendations are always well considered. They are well debated. They have an established methodology of consultation, public consultation, and consultation with all stakeholders. So having that advice before a decision is taken is always helpful. And in any case, the final call has always been, both in the past and under the law as it stands, with the government. The thing is, it may well be, I mean, I would still perhaps give some benefit of doubt that maybe the intention is to still obtain recommendations, but the way that the law is worded perhaps gives an impression that government would take those decisions without consulting TRAI as required under the TRAI Act. And since this act would presumably override all other existing legislations, to that extent, the provisions of Section 11A may not be applicable. That's the apprehension. But as I said, I wouldn't make a very big deal of it at this point, unless it becomes clear that the intention is to not seek TRAI recommendations, which would be, to my mind, a little inexplicable.
Yeah, well, so you're saying that at this point in time, let's give the benefit of the doubt to the government. But Mr. Chandrashekhar, you're saying that you don't want to make a big deal of this specific issue. But is there anything in the bill at this point in time that you do want to make a big deal of, since we are talking about fixes before it becomes law?
Yes, absolutely. I think, I would not want to chase after red herrings at this point. I think, there is a fundamental shift that is happening in the regulatory architecture of the digital space. And that is the point of major concern. What is the shift in the regulatory architecture? As the earlier speakers also brought out, it's currently looked at from the perspective of carriage and applications and content. And by and large, the carriage is what the DOT's domain has been in terms of regulating. There has always been a case for bringing in convergence, so that irrespective of the mode, whether you use cable or whether you use telecom infrastructure, all of them should be regulated under a single law as far as carriage is concerned. So bringing them all together under a single legislation is eminently desirable. However, the boundary line has been in the past, the applications and the technology part has largely been regulated through the IT Act. Now, it's sometimes said that, what's the big deal? OTTs were already regulated under the IT Act, and if they are brought under the Telecom Act, why are people so exercised about it? Well, there are several reasons why I think this is a matter of concern. For one, the telecom law starts with a premise, or starts with a statement, axiomatic statement, that this is a sole preserve of the government. In other words, anybody who does anything in telecom, as far as the carriage is concerned, does so by leave of the government. On the other hand, in the IT sector, and perhaps even in broadcasting, it is the other way around. You can do whatever you want with certain exceptions, which the government would lay down. There's a world of difference between the two. There's also a very practical reason why this combination of heavy-handed regulation and light touch regulation is not only necessary, but is the only way forward. Because telecom is local. It is only within the boundaries of the country, and the law also is local. It applies only within the borders of India.
Right.
But digital content and digital applications are global. And beyond a point, you do not have the ability to enforce some of these provisions. And therefore, again, that becomes a big issue. So I think bringing some of these hitherto, issues that were hitherto covered under the IT Act, under the telecom, is an issue. The second is the definition. Now, it appears that the intention is to bring only OTT communication services and not all OTTs. But there is no clarity on what is an OTT communication service. Because remember, every OTT service does have certain elements of communication. Some of them may be encrypted, some of them may be not. Even an e-commerce service does have some communication. Even an Uber has some communication. And therefore, the definition that is there lends itself to any kind of explanation or any kind of interpretation. So that brings in certain uncertainty as to what might be regulated tomorrow. That uncertainty, I think, certainly is not at all a good thing for the startup ecosystem. It's not a good thing for innovation either, because innovating in a space which is tightly regulated is always a problem. So I think from both these points of view, the implications for the startup ecosystem and for a number of OTT services, all of which to varying degrees do include some communication, would worry me a little bit. There are, of course, many good provisions, and the overall intent in terms of protecting users, easing the meeting process are all good. But this
since we're trying to elicit comments on what needs to be fixed before the government closes its window for comments, we are focusing on the points of concern. But Rahul, let me come back to the point that Mr. Chandrashekhar raised. And, as former DOT secretary and former president of NASSCOM, he's saying that he is concerned about the implications for digital entities for the startup ecosystem. Would it be an exaggeration to say that in its current form, what the bill is proposing, we could in fact be headed back into an era of license Raj, because it is at this point in time saying that all entities, whether it's a WhatsApp or a Google or a Cisco or a Skype or a Dish TV, will need to secure a license from the DOT. Would that be an exaggeration, or would that be a legitimate concern?
Well, at this point in time, it may be an exaggeration, because I would say that we still have to see what the new licensing framework is. So let's just try and understand what we've seen so far. We've seen the Telecom Act, this Telecommunication Bill, replace the Telegraph Act. But the Telegraph Act is not our entire regulatory framework. The Telegraph Act, along with the licenses, is the regulatory framework that we currently enjoy. So if you say that the Telecom Act is now replacing the Telegraph Act, and it has brought a lot of what was previously in the licenses into the main body of the statute, we are definitely looking at a completely different, different framework of licenses. And so I'm expecting that the licenses will be much slimmer and will have much fewer provisions. In that framework, we also need to take a look at what is being licensed. And I think, there are provisions, at this present point in time, lots of things are exempted from license. I would have liked, in Section 3 of the bill, which provides the exclusive privilege, for a subsection to actually specifically state that certain things are exempted. If you just think about, the intercom service that you have at your CNBC office. Now, that is a telecom service, but you shouldn't have to get a license for it, because that is just within your offices. And similarly in my office. And you don't, at this point in time, need a license. And I think under Section 3.3, we will be granted an exemption, but it would have been really nice if the government had put it into the law in a 3.4, which said that nothing here in the Act prevent a private telecom network. And in this manner, there are many other things that perhaps if we had excluded in the law would have given businesses clarity.
Okay, Gopal, since we are seeking clarity with this bill, and today we're talking about what needs to change before it in fact becomes law, go ahead, the final comments with you, Gopal.
Look, I think the most important thing is when we look ahead, which is forward-looking, we have to move away from the old concept of licensing to a trust-based system. Electricity Act liberated generators from licensing. Telecom infrastructure only requires a registration. Supreme Court has held the terms and conditions of a license are contractual. So let's not live in a bygone era. When we shift, we have to shift lock, stock, and barrel and not bring in expanded licensing. We have to move clearly away from that. So I think the intent is in the right direction, but the manner in which the intent is perhaps going to be implemented, we need to do a rethink and immediate course correction so the act can be implemented and is workable, doesn't run into legal challenges, jurisdictional challenges, and does not become an albatross around the neck, because licensing in telecom only led to disputes, and at least 4 types of licenses were changed over 20-year period. So those are examples to show what to stay away from. So I think we should really think of a new age way of doing it. Authorizations, permissions, contracts, they're all there on the table. So let's not just think of licensing as the only way forward.
Yeah, well, that's just one of the big takeaways coming in from this discussion. And when you have lawyers on the panel telling you that, look, more needs to be done, immediate course correction needs to be done to ensure that there are no disputes, that means that there really is a warning being sort of signaled there. But for this afternoon, R Chandrashekhar, Apar Gupta, Rahul and Gopal Jain, many thanks for joining us. As we said, till the 20th of October, the government has invited comments to come in for the new telecom bill. This is, of course, the draft that is under discussion at this point in time, and our panel today has suggested areas that require fixes before it becomes law. We will continue this dialogue and this discussion, but for now, on Business 360, many thanks for watching.